But their two options are basically consent or have a hearing. And so, again, if they're calling my office and they're calling us for representation, usually they're not consenting. There are a small percentage of cases where the evidence may be just so overwhelming that we would advise our client in those situations to consent and let's try to mitigate this. We don't want to have a hearing. Maybe there's also a criminal case at play because they've been charged with domestic assault and we don't want our client testifying. So there are some situations in which we would advise our client to consent, but by and large, if they're calling us and they're hiring us, they're not interested in a consent. They're wanting to fight this, and that's what we do. And so as far as the question getting it dismissed, we don't have that control. The petitioner does. They are the one who filed the order of protection. Oh. Only they can dismiss this. We have to be ready to walk in there, and I always tell our clients is, you hire us, this court date is on, 2 weeks from now, we're gonna be ready to rock and roll. We're gonna walk in there ready for a hearing, ready to, put on to cross-examine the petitioner, put on the testimony of our client, the respondent, and we're gonna be ready for a hearing. So we don't necessarily control the dismissal.